When you're up against a hostile room of people who don't want to be there, you need real strategies that get results. Welcome to From Hostage to Hero, the show that gives you practical advice you can use right now in the courtroom, boardroom, or classroom. Learn how to move your unwilling audience to one that is invested in what you're saying, eager to participate, and engaged in the process. Learn from the attorney whisperer herself, your host, Sari.
Well, welcome everybody to today's podcast. I'm very, very excited to welcome Bruce Inocencio, because that's such a cool fucking last name, and his team to talk about their recent win of $6 million in a case that before trial had an offer of $250K. So welcome to you, Bruce and Christina and Ryan. Thank you so much for being here.
Yeah, thank you for the invite.
Thanks for having us.
Thanks for having us.
Excited. So excited to talk about you. So tell me, before we get into this, Bruce, tell me about you and your team. Where are you guys located? What kind of law do you specialize in? What kind of cases are you normally doing?
Yeah, so our primary office is in Jackson, Michigan, and we have another office that Christina pretty much handles up in northern Michigan in Sheboygan. And then we have offices also in Florida and in Texas. I'm admitted in both Florida and Texas, and have been in Florida for about, I think it's 18, 19 years now, and in Texas for just a couple of years. And I've been admitted to practice since '96. Met Christina. She was a job applicant, kind of just worked out here in 2000. And we've been working together for 24 years. She became a partner.
So she started when she was like 8 years old, apparently.
Yeah,
that's not possible.
Pretty young and young looking, but it's been a great partnership. And we try different cases, but we try a lot of cases, teaming up. That's kind of our approach. And then Ryan's been with us for a number of years. He started with us while he was in law school, actually, transitioning through COVID and everything. So he's been with us for a while as well. And we try different types of cases, but we try to implement your methods here, since I learned about them through Trial Lawyer Nation through Michael Cowan.
Oh, Michael Cowan. Yeah, I love that guy. So Ryan, you've always been plaintiff side then, yes?
Yes, this is the only firm that I've worked for, and I've been here, I think, since 2018.
Well, that's wonderful that you start on the side of the right. Love that. Christina, your background before you met Bruce?
So I grew up in Alaska. I'm originally from Michigan, but grew up in Alaska, moved back for college, and I started with Bruce right out of law school as an associate. We became partners, I think, in about 2009,
right.
Maybe a little. Right. Yeah.
Right.
And we've been partners since. I've never worked for anyone else with anyone else. Bruce and I have a great partnership. It is very, it's just very fulfilling to be in a firm like this, where we've all stuck around for the long term, and we've great staff.
Yeah.
Our associates are amazing. Ryan's been fantastic, and it's just a great place to work. So I practice a little bit different than Bruce. I help and assist with his injury cases, but aside from that, I also do a lot of business, real estate, and some general litigation as well.
Got it. Okay. Well, let's dive into this case. So give us a little bit of an overview. What kind of a case was it? What were some of the things that you had to overcome?
Yeah, sure. So Christina first met with our clients in 2018, and then I met with them shortly thereafter. And our clients were 4 adult children of Mrs. Taggart, and she was 87 years old at the time, and she had had a stroke, and she was a stroke rehabilitation resident at a nursing home in Lenawee County, which is just south of our county, near Jackson County. And Lenawee County is a pretty conservative venue. We knew that going into the case. Her doctors expected her to come home after a few months, maybe, of rehabilitation. This is not a situation where she was put into a nursing home and expected to live out her days there. And so she was expected to come home, and her daughters all expected her to come home. And what ended up happening was she became severely dehydrated, and she was at risk for dehydration. And she was on some medications that suggested that it was easier for her to become dehydrated. But here's the key: she had a tracheostomy. And so she was 100% dependent upon the facility for maintaining her nutrition and hydration, and she couldn't communicate with them if there was a problem. So they had to take very good care of her and monitor her needs. And they didn't really do that. They were indicating that they were, but they didn't really. And so early on, she went 10 days, like her first 10 days at the facility, she went without a bowel movement. And after 3 days, all the experts in this case said that you should probably have some type of an intervention, some type of a change in status would be noted. And so after the 10 days passed, then she had a situation, and then she went for a couple of days where it was normal. And then she went for 17 days again without a bowel movement. And so again, she had another instance where clearly something should have happened and nothing happened for her. And so the jury eventually, realized, hey, this is negligence. You can't say that you're doing something and monitoring someone when you really aren't. She ended up having severe dehydration, severe fecal impaction, and then she also developed, as part of her dehydration, a brain injury known as toxic metabolic encephalopathy, which is a situation where your brain is just drying up and you're not able to function as well. And she lost her abilities to communicate when she came in. Even though she couldn't speak, she could point to things, or she could make hand motions or gestures. And so it was a situation where she had functions and she was expected to go home with those functions and improve. They were giving her all kinds of therapy: speech, occupational, physical. And at one point, one of the physical therapists actually administered therapy to her, determined that she was non-responsive, and went ahead with a therapy session anyway. And so there are a lot of instances where we just felt this was a fairly clear-cut case of abuse and neglect, but the defense fought us hard on it for a number of years, and we ended up, having to go to trial on this because the offer was just really, really low.
Well, yeah. And so what happened? Did she actually die there, or?
Yeah, so she ended up being transported to a hospital directly across the street, 50 yards away. And at that hospital, that's where they diagnosed her with laboratory evidence of severe dehydration. Her markers were just off the charts low, indicating that she was severely dehydrated. And the severe fecal impaction, she had a 10-centimeter wide, for lack of a better term, her abdomen was full, right? And so they determined that she was so badly dehydrated and her kidney function was so poor that she likely would not recover from it. And she ended up in hospice, and she died 17 days later.
My goodness. So,
Yeah.
So let's talk about what you had to overcome. I'm going to go over to Christina now. So obviously, right off the bat, in all of these nursing home cases, we have to overcome the fact that the person was 87 or whatever years old, and they're going to die anyway, right? And she had a stroke. So there's all of that we always have to overcome in these cases. What are some of the other issues you had to overcome in the case, Christina?
Sure. So that was absolutely one of the biggest things there. And they focused a lot on that during the trial. And we tried really hard to give the impression that this wasn't just a person of older age. This was a person who had years ahead of her in life. Her family expected her to come home. And for all intents and purposes, she would have recovered, but for the lack of care that she received. One of the other things that I think was a hurdle that we worked really hard for, unfortunately, we didn't necessarily overcome it, was the difference between a standard negligence situation and a medical malpractice situation. In Michigan, we have there are different claims for those two types of things. And in our opinion, this was a clear-cut case of negligence versus a medical malpractice issue. There was a lack of care, no care, versus a breach of some standard of care. And quite frankly, that's something I think that needs to be addressed, and hopefully is focused in the future on nursing home cases, because I think this happens pretty frequently, where it is just a straight up lack of care versus a failure to meet a certain or breach a standard of care. Aside from that, I think there was a perception on opposing counsel's part that there was some perceived fault of the sisters in how they proceeded with her. They perceived her care while she was in hospice, and an ultimate decision on whether or not to withdraw life-sustaining care at a point where doctors advised that she would not recover. And that was really unfortunate that they focused on that at trial, because I believe, based on our observations of the jury, that it did not go over well with them, that they were trying to flip that onto the sisters. And Bruce did a great job of refocusing the attention away from that and explaining that at that point, she was so far gone because of a lack of care that this was inevitable, and they didn't want her to suffer any longer at that point. So I would say that was
So
that was
it
just
was
an
actually
interesting
fortunate.
focus.
Fortunate that they did that, because I mean, as painful as that would be for the girls, they will stoop to any level in many of these cases. And oftentimes in nursing home cases, they end up blaming the family, or there's a perceived that we think the jury's like, well, if you actually loved your loved one, you would never put them in a nursing home, right? Those are horrible places. So there are lots of things to overcome. Did you also have to meet a different standard? I know in many nursing home cases, you have to meet the standard of malice, oppression, fraud, or
No, we
was it
didn't have
just
to
a
do that.
standard?
No,
Okay.
we didn't have to do that. The issue was whether or not there was medical judgment. And our approach was that there was not medical judgment. These were discussions that we were having outside of the jury's presence with the judge relative to whether or not there was medical judgment to do nothing, as opposed to you knew of this risk, and in the face of a known risk with a person who has ongoing issues of dehydration or a known risk of dehydration, you did nothing. And doing nothing is not medical judgment. Doing nothing is ordinary negligence. And so
it reminds me of Rick Friedman's Rules of the Road, where he says,
right.
when something is particularly dangerous, you have to have even more care, right? So she was particularly fragile, so they needed to be more careful than less. Right. So talk to me about who did what in the trial. What was everybody's roles?
Yeah, so I'll start. So one of the things that we really like about the way we approach cases, and some firms will do this too, but we're not the only ones doing it, but we really try to be interactive with the jury. We recognize that jurors have short attention spans. I know how you feel about the duration of an opening statement. I did my absolute best to keep it under your perceived perfect cutoff point. And
how did it go?
I got close. It wasn't exactly there, but one of the things we really try to do is we do try to engage the jury. And so we used a lot of foam boards that were specific aspects of the medical records. We wanted them to see one particular sheet, and we'd highlight it. And I'd stand in front of the jury and I'd walk in front of each one of them pointing at it. So they were looking at that and I wasn't talking. So they're seeing it. And Ryan's sitting there next to me looking at them. Hey, are they engaged, right? Then we used a vibe board, which is a 55-inch flat screen television that's touchscreen. And we would broadcast different rules from the regulations, the federal regulations, to the board. Or we would broadcast something from the medical records to that, or the video deposition transcripts that were cut and pasted as far as exactly what we wanted the jury to see that we agreed upon with opposing counsel. Ryan did a fantastic job of taking the lead on getting all of those video transcripts. I can tell you a couple different times we were on the phone 1:30 in the morning from the day before to the next day saying, hey, listen, we need to tweak this, we need to tweak that. And having the commitment to getting those pieces of information in front of the jury in a video is critical, as opposed to just saying, hey, you said this, didn't you? Well, let the jury see it themselves, right? Mm-hmm. Let the jury see what the person actually said. And so they can make their own assessment without me leading them to it, right? So that was really helpful. Another thing that we did is we bounced around as far as who was at the table. I was always at the table, and we started with, did we start with Ryan at the table? Yeah, we did, didn't we?
Did we for opening?
Yeah.
At counsel table?
Yeah. And the reason we did this is because my thought was this. I want the jury to see that it's not just me trying the case, it's a team. Okay. And so we had me, I'm obviously older than Ryan, and we had somebody younger. And then Ryan stepped back, and then we had Christina come up, and she was there for part of the trial. And we're all there for the whole thing. But then what's happening is they're seeing it's not just two guys trying this case. It's not just the older partners trying this case. And then we also had a paralegal who is studying for the bar right now, Val, who also was there for the entire trial. And so anytime a decision needed to be made, we'd pause, we'd kind of huddle up, and it would be a four-person decision. And so the jury saw that we were working together as a team. That wasn't fake.
I love that. And did you do the voir dire in opening and closing?
I did the voir dire. Yeah, I did the voir dire opening and closing. And I can tell you that, and this is not a shameless plug for your book, your podcast,
I'll
all this stuff,
I'll
but
take
I'm
it.
about to. But I'm about to. So what was really cool about the voir dire in this case was we were allowed to ask whatever questions we wanted after the judge did his opening questions. And we really used the voir dire to establish the principles and get some feedback from the jurors. And we could feel, I think, right away that they were coming along with us and that they were allowing me to lead them in this tribe, right? That was coming through. But what we knew when we knew we had it was our client, we only had one of the four daughters in court the whole time. She happened to be sitting over by the door of the courtroom. And when voir dire was over and when the jury was impaneled and the judge said, okay, the rest of you are free to go, they all got up, they walked out. And as they walked past her, many of them said, go get him, don't back down, stick it to him. And so she told us that out in the hallway. And I thought, wow, okay, that resonated. And they hadn't heard any facts other than the way we explained what we were trying to convey and what we would be conveying in the rules. And I think the voir dire, the approach that you have with this inclusionary voir dire was critical to the outcome of this case. No doubt in my mind.
Well, and let me ask you this. Had you tried the H2H voir dire in a case before? Was this the first time?
So I had tried it in another case and got a great outcome. And then Christina also, without having read your book, I said, you're going to do this voir dire. Just trust me on it. You're going to love it. I will write it out for you. And I even went to the point where I was put into the explanation. Okay, at this point, hold your hands up a certain way. Make sure you're breathing. And I put in there, I know you think this is crazy, but just please trust me on it. And she did, right, Christina?
I did, and it worked out very well. And one of the components I thought was amazing was the concept of having the jury give you words that they think are so my case was dealing with a real property issue and damage by a neighbor to my client's property, and they came up with words like unfair, justice, all these different key phrases, and then using those in my opening and my closing to wrap it up. That was amazing, because I think that actually they're their words, and they're using those words, they're describing the situation exactly how it existed. And I thought that was a great technique. So it did work. I
love it.
I
love it.
I was very skeptical, I have to admit.
Well, yeah, because y'all are trained the different way, right? So we were just on a call right before this in the crew in the H2H playground talking about cause challenges and whether or not we use them in the H2H method. And the consensus is, yes, there's a time to use them. But when we say inclusionary, we're not saying, well, we just accept everybody. What we're saying is that we go with forming our group first, that's always the primal first thing. And that we're going to get them to tell us what the principles are. And they're going to get them to rally around those principles. And then we'll deal with people who are not in our group. But we're always first going to be like, where's my group? And where do I find them? And how do I know that they're there? And it's all about having them give us the principles in the case versus the other way around, and then asking if they agree. And did you get any blowback in either of these cases from the judge? Because I think a lot of people are like really fearful, like the judge isn't going to let me do this.
We did not get any blowback. I was prepared if we did get some blowback to maybe pivot a little bit, but I think the judge allowed us to go with it a little because opposing counsel didn't object. And frankly, even if they had objected, what's the basis for the objection, right? You have to have a legitimate basis for the objection. I think people are so often just afraid to try something different, whether it's voir dire or cross-examination of an expert. But if you don't attempt it, then you're never going to know. And I will say one of the questions that we asked here at the very beginning was, how many of you here have ever known someone that's had a stroke? And almost everyone in our panel had.
Absolutely. Mm-hmm.
And so we started asking questions. And one of the jurors had a son that had a stroke when he was 4 years old.
Oh my goodness.
And so the fact that he was 4, and I think she said he was 31 at the time of the trial, if I'm remembering this correctly, he lived for 27 years, right? And so to get this sense that, okay, this person's old, sick, and dying, she's had a stroke already, she doesn't have any quality of life, that would be completely refuted by that juror. And we had a number of other jurors who talked about loved ones, whether it was a dad or a grandpa or an uncle, that recovered from a stroke and they were doing fine. because they went through rehab and they were cared for and they had the care they needed. And so we used that. You probably don't remember, but about a month before we did this trial, I did a voir dire circle with you.
I was just going to
and
say, yeah.
You kind of got after me for not doing my devil's advocate question with enough snark.
I
And
was
so
just going to ask, did you do it?
I did, and it worked.
Yay.
It
Okay.
worked because then when people are saying, yeah, we would expect that there's a high level of care, even if someone's 87 years old, right? Those are, like Christina said, those are now their words. And if
Okay.
you
And
want
so
to
how
argue
did you
with them,
devil's advocate it? How'd you devil's advocate it? What did you say?
but something to the effect of, you wouldn't expect that they'd still have a high level of care and need to be monitored, even if they were already at risk for dehydration and they're 87 years old, would you? Oh, yeah, we would. I remember the juror at the far right hand. I remember her saying, yeah, that's probably even more important of a time to monitor her care. Right?
And you still need more snark. But I love that you did it.
Yes.
And for those listeners who are like, what the hell is a devil's advocate? So that is where we never funnel a defense point, right? We're never having the jury give us defense points or refuting defense points. We're always going for our principles. But then once we have the principle, and only then, we'll shake the tree a little bit and go, yeah, but I mean, she was 87. She's had a stroke. She's going to die anyway, right? And then the jury's like, no. And they come roaring back because we've done this defense point. Ryan, you were there watching this. What were you noticing about voir dire opening or the parts of trial that you observed?
Yeah, I think I have a unique perspective in that this was actually my first trial. So every aspect of this was a new experience for me. I've heard Bruce and Christina's past experiences, but literally being in there and seeing them, it's the first time. And with regard to jury selection, there's two things that stick out to me that I think kind of really benefited us and that I think Bruce did well with. I think once we already had our team, right, our jury that we liked, they were really engaged and comfortable with. There was one individual who had a conflict relative to a out of town funeral, and the concept of being inclusionary as opposed to exclusionary, we talked about, but Bruce, let her off, or at least advocated for it, and it came across as though it's sympathetic, right? It wasn't, we don't want you, but we recognize what you're going through, and we don't want you to miss that. And I think that really hit home with a lot of the jurors, because when they go back into the jury room, they're a team, right? They're friends, or they become friends. So I think that held a lot of weight. And then secondly,
but that was a gimmick, right? I mean, Bruce was using that as a gimmick, wasn't he?
I wish we'd figured that out in advance.
Right. I mean, I think that's the point, is that it was so genuine, and jurors feel that, they get that.
Right. And I think the second one, I think Bruce can probably speak a little more to, but there was one juror that was, I think, the last to sit, and it was a younger gentleman who, just outwardly didn't necessarily look like he would want to be involved or would be too engaged. And Bruce, I think you can probably explain how you brought him in and made him like a focal point to where he felt really important.
Yeah, so I remember this juror. He's 22 years old, and all of our other jurors were probably mid-30s or older. A couple of them were probably in their late 50s, early 60s. And I kind of felt like, okay, he's going to feel like an outcast, right? How do we bring him in and make him part of the tribe, so to speak? And so asked him a little bit about what it was that he did and what was his role at work. And he worked for a company that deals with brakes, automotive brakes. And he talked about quality control and how important it was. And he talked about, doing something and then checking the box, not just checking the box and not having done it. Well, in our case, it was almost like this was planned, right? But in our case, we had these medical records that included these X's for check boxes indicating that someone had checked on our client, or our client's decedent, their mother, for purposes of checking to see whether or not she had been checked for constipation or dehydration. And all these boxes are checked. Well, nothing really happened. But so we asked him, okay, so how important is it? What would happen if someone were checking the box and they weren't actually doing that? Tell me more about that. And he walked us through how important it was to not just check the box, but to actually do it. And then what could happen if people are not doing what they say they're supposed to do and they're just checking the box? Well, gee, you know, my whole plant would shut down. Everything comes to a grinding halt. I said, so even though you're just one little small cog in this entire operation, you're important to the outcome. Well, yeah. Okay. And if someone doesn't do what they're supposed to do and they're checking the box anyway, oh, I'd get in trouble. I'd have a huge problem on my hands. Well, that played right into our theme. And I brought that back in opening, and I brought it back again in closing.
You brought it up with witnesses too frequently, which I think was important, drawing attention to that issue.
Yeah, and pulling it all the way through. So opening went well, it sounds like.
I think so.
Christina, did you do any part of the trial, or was it all Bruce with direct cross-exam as well?
I was not I did not do any of the trial functions in the way of questioning witnesses, voir dire, opening, closing, any of that. I was a casual observer and an assistant, to be honest. So Ryan did a lot of the hard work in the way of providing Bruce with information at the table. Val, our paralegal, and I sat behind them, and we observed the jury, listened to the witnesses, took notes. It's very difficult, obviously, when you are the lead on something like this, to hear all of the answers, to digest everything, to think about follow-up questions and all of those things. And so I was texting Ryan profusely, I think, through every witness: tell Bruce to ask this, tell Bruce to ask that, maybe we go into this. And so it was that kind of contribution. And then when we convening after every day and talking through different issues, things of that nature. So I was very much a support person in this whole thing.
Which is so helpful for the person out there performing, quote unquote, to have those extra eyes and ears, seeing things. You know, people now say, will you come help me pick a jury? And it's like, if I don't know your case, I'm not going to show up. Like, I'm not going to be helpful. But for people who, you know, worked with me and I know their case, I said, I'm really just there to confirm your sanity, to say you're seeing the things the right way. You're seeing, yep, I agree with that. You know, just to be there as that extra set of eyes, to say, yep, this is going well, or let's shape it this way, or let's do it that way. That's so incredibly helpful. How did you feel once you handed it to the jury and they were off to the verdict room? Did you feel like you had it at that point? What was the feeling there?
Well, I think Christina and Ryan were still in shock from my ask of the jury, because my ask of the jury.
You didn't even tell them until it flew out of your mouth?
I kind of, I changed it up a little bit that morning. I kind of had a little bit of an epiphany about how I wanted to structure it. And then it went a little bit further because their expert witness testified last. And fortunately, he said that her life had value. He had said something the day before that did not make him look good. And I'm sure he was chastised and told, hey, you need to correct this somehow. One of the last things he said was, her life is always going to have value. And I kind of seized on that and talked about the fact that, you know, they're only thinking that she was going to live 3 more months. Well, let's talk about those 3 months. And in Michigan, we can do a per diem argument. And so I broke it down, and I got a little choked up telling a story about my grandma, and it was legitimate. I wasn't faking that. And I talked about that even in voir dire, and about the value of something that no one can put a price on but you. And mine was an old 50-year-old plastic water pitcher that no one would pay anything for. But to me, it's priceless, and it truly is. I think the jury sensed that I was not making that up, that was sincere, and that's how our clients, all 4 of the daughters, felt about their mom, and that you cannot put a price on that. And that's what I tried hammering home in voir dire. I asked about that, talked about it again in opening, and then talked about it again in closing. And I think another thing that helped me connect with the jury a lot, that was helpful, I think, from Ryan and Christina's perspective, is they're feeding me information, right? And they are giving me notes periodically. Hey, you're losing the jury on this topic. Move ahead, you know, with witnesses. But during the opening and during the closing, I did not have notes. I followed your lead on not having notes. And I've been doing that for a number of years. And I think it works really well, because you're now looking at each juror, not staring at them, but you're getting eye contact and you're moving from juror to juror, and you're looking at them saying, hey, sometimes you can have someone that has a stroke and they can live for decades beyond that. You're looking at the particular juror that talked about that.
Yeah, that's right.
You're looking at the juror that talked about, you can't just check a box, right? And you just pause and you look at that juror, and that juror's like, yeah, they're nodding their head. If you're looking at your notes, you're not doing that.
Nope.
And I think having the ability to know enough about this case and having lived it and trusting that you don't need to talk for 3 hours. You need to talk for maybe 18 to 30 minutes and understand your main points that you want to get and connect the jurors.
Sitcom.
Yeah. 22 minutes is the sitcom. It's the TED Talk, right? I think that is critical. And we were able to do that here.
Well, and I think that's so great that you did without notes, because the other thing that it does when you're have notes and you're really stuck to your notes is, I don't know this case very well. I'm just here for the money, instead of, I know that this is in my bones and I'm just going to talk to you about it, because it's wait till you hear about this. It's just crazy. Right? And you guys are going to want to fix this. All right. It's a more connective thing versus, okay, well, I got to get through this, so you guys will give me the money, right? And have my notes in front of me. Not that there's anything wrong with an outline and whatnot. How did H2H help? How do you think this assisted you?
So I would say, in addition to not using notes, what you talk about in the book and the podcast is you talk about the nonverbals, right? How you stand, how you're breathing. I remember distinctly, I know Ryan will remember this, legal pad right between us at the table. We're about to get started. I'm starting to get a little nervous, right? Because I know how important this is to this family. We've been dealing with this issue with them for 6 years. I don't want to screw anything up. And the mindset is, hey, we're taking this thing to trial. We're not backing down. We're not going to settle and walk away. And what I love about working with Christina is the same way. We're not going to back down. If we think that we should take this case to trial, we're taking this case to trial. But I remember writing on this legal pad in all caps and underlining it, breathe.
Breathe.
And Ryan's looking at me like, is that for me or is that for you? And I said, well, it's really for me, right? Because you start to forget, hey, you got to breathe and you got to just relax. And one of the things you talk about is breathing through it and getting some comfort so that the jury is breathing with you and they're comfortable. I felt like once we started, we were doing that. And the nonverbals about, and this is one of the things I wrote in the thing to Christina about her trial. Hey, the way you stand, the way you hold your hands to be authoritative, but not pointing at them. I can tell you there were probably 6 or 7 times that opposing counsel was pointing at the jury and not in a way that I felt was helpful. Let's just say that. And so using the nonverbals, not using notes, keeping your witnesses tight, using the themes and getting the principles from the jurors, all of those things I clearly stole from H2H. There's no, I mean,
there's no stealing. They were given to you, and you're a part of our crew, our H2H playground. And when you mentioned the voir dire circle, that's where people can come in and get a hot seat. And I coach you live doing your voir dire. And it sounds like that was helpful. I will say one thing, that breathe is for Ryan and anyone else there, because if they're breathing, that's going to help you. So like their number one job when they're there, before the jury comes in, is like just to focus on their breathing. So it will help you, right? Because we want all that good breathing in the air, because the jurors are going to come in and be like, oh my God, I don't know what I'm doing. I don't want to be here. And if you're also like that, then we're all like this, versus I got this. And so Christina and Ryan are behind you going, like, even if you make a noise, guys, just like that. So he can hear that. That's going to remind him to calm his nervous system down and really get grounded. So I mean that quite honestly. The whole team needs to be breathing, especially for the person who's out front. Well, I just want to congratulate you all again. I just love seeing teams that work together so well. I love that Ryan is learning the right way from the very beginning by being with y'all. And it sounds like he's loving it, and that you and Christina have such a great partnership. I love seeing you in the crew, Bruce. I want to see you in there more often. Of course, Christina and Ryan are also welcome. But congrats again. What would you say your big learning from this, if you had to put it in one sentence, from this case that maybe another attorney listening would be like, that's great advice? What would it be?
Trust the jurors to give you the principles that you need to win the case.
That's right. And that's a hard thing to do, is to trust the jury. That's where we start, as you know, in H2H.
Yep.
Well, thank you so much for being here. And if those
Thank
of you
you.
listening, I hope you enjoyed, and we will talk to you next week.
Thank you.
Thanks for having us.
Thank you.
Thank you.
Yeah. Have you ever wished that you knew what the jury was thinking? Well, grab a pen and paper, because I'm about to give you instant access to a free training I created for plaintiff trial attorneys called 3 Powerful Strategies to Help You Read a Juror's Mind. It's going to help you to understand what the jury is thinking, so you'll feel confident to trust them and yourself in the courtroom. Ready for the address? Go to sariswears.com/jury. Enjoy!